Common law relationships are on the rise in Canada. However, many couples are unfamiliar with the legal rights and responsibilities they have should the relationship break down. To explain what those rights are, we are joined this afternoon by Stuart Zuckerman with Zuckerman Law Group. Thank you so much for being with us today.
Happy to be here. Thank you.
All right. Now, the laws around common law relationships changed in 2013. So how is it now defined in BC?
So in 2013, the Family Law Act came into effect in BC, and it provides that couples who are in a common law relationship have all the same rights and responsibilities and obligations as people who are married. So it's important to understand what a common law relationship is. You have to be in a spousal-like relationship for 2 years or more. Once you pass or hit the 2-year mark, you are a common law couple. Or if you have children together, you may be considered a common law couple just for the purposes of spousal support and child support. But for purposes of property division, you have to be together, or pension division, or debt division, you have to be together 2 years or more. And then the law treats common law couples the same as it would married couples. So if you're in a common law relationship and you separate, whatever each of you brought into the relationship on the day of cohabitation, that equity in your assets is yours. It's excluded from division. But the growth in equity from day one to the day you separate is split 50-50. So the growth in equity in a house or in an RRSP or a pension, if you're in a common law relationship, that growth during the relationship is subject to a 50-50 split.
Do you get the sense that a lot of people don't understand what their rights are when it comes to common law relationships?
Absolutely. I recall a case I had many years ago where the so-called wife, they weren't married, but the woman in the relationship who owned the property, in court papers at the beginning of the case, referred to her spouse as a renter. Despite the fact that they were together 14 years and had 2 children together. And she somehow thought that if she was the landlord and he was the renter, that the courts wouldn't give him an interest in her property. But we went to court and got him a third of the equity in the property. That was before the current law. But under the current law, you do get a lot of people who, I hear this all the time. Typically women come to me and say, my partner who controls the finances and whose name is on title to the house says to me all the time, I have no rights, I have no interest in this house, it's his house, he owned it before he met me, he made all the mortgage payments, I haven't contributed to the mortgage, therefore he says I have no interest in his property. Is that true? And it's not true. In that case, the woman has a 50% interest in the growth in equity. I had a recent case, a woman named Carolyn, the husband had 3 properties and told her she would not get a penny and made those kind of statements to her all the time that she had no right because they weren't married. We ended up getting her over $750,000 in those properties. So
now, it can get a little bit complicated, though, because laws change province to province.
That's true.
So if you begin your relationship in British Columbia and then you move to a different province, what happens then?
Right, so the court looks at what's called habitual residence whenever there's a legal dispute. So that the court may have to determine what was the habitual residence of the couple right up to the date that they separated. And the court, if you're resident in one province for 1 year or more, typically the court will consider that province to be your habitual residence and the laws of that province will apply. So if you lived in BC for 5 years and then moved to Alberta for 1.5 years, it would be the Alberta law that, and then you separate, at the end of that 1.5 years, it would be the Alberta law that applies because that's the habitual residence at the time of the separation.
Okay. Now, in terms of clients that you see, what is the number one concern? Is it property or is it division of other assets?
Well, often the number one concern of the partner with the lower income, whether that's the woman or the man, is if I want to separate or if my spouse wants to kick me out, how am I going to pay the rent? How am I going to feed myself? They're the breadwinner. I'm dependent on them. How do I make ends meet? So often it's the first step is about getting spousal support or alimony in place right away, so the person can leave. You can go to court at the time of separation and get a somewhat division of the parties' incomes in order that the lower income earning spouse can have some money to rely on to pay their bills.
And I imagine there can be situations where the higher earner is able to maybe tie up the other in legal fees or in legal proceedings, and that other person may not be able to afford that. So that can be a big barrier for a lot of people.
Absolutely. In that case that I recently talked about, the Carolyn case where I got her $750,000, she had no money. Her husband was the breadwinner, and she was concerned about her ability to, and he was determined to fight all the way to court, and we actually went all the way up to a week before trial, before settling. But we were able, you can bring applications to force the sale of properties, and then you can actually apply to court for an advance out of the equity to each of the parties to fund legal fees or experts. So that's provided for in the rules to get an advance. And the other possibility, when there's money in the bank or things of that nature, you can bring an application again to get an advance out of those funds or for support to help finance the litigation.
All right. Stuart, I want to thank you very much for joining us today and answering some of those questions.
My pleasure. Glad to be here.
I have to separate from him. I just can't take it anymore.
Oh my God. What about your kids? And your house? How can you afford to separate?
I just don't know what to do.
There will be many tough questions about the process, your children, finance, and child support. Not to worry. Get your answers now. Free initial consultation, no obligations. We provide guidance and support through the toughest time of your life. We're on your side. Call now before your spouse does.